Welcome to Dorsey and Whitney's webinar on the ascendancy of online everything, how Canadian companies can reduce legal risks regarding US website users. I'd like to introduce Dan Miller, Vancouver office head and a partner in Dorsey's Capital Markets and Corporate Compliance Group. Dan?
Thank you. Hi, I'm Dan Miller, as you heard, the head of Dorsey's Vancouver office, and thanks for joining our session today. As the internet becomes increasingly crucial for businesses today, the U.S. legal framework is rapidly evolving. In addition to federal law, each of the 50 states are making their own laws, some of which have significant impact on business. Staying on side of the rules is an increasingly challenging minefield for companies to navigate. We plan to cover a lot of material over the next hour, but first a couple of housekeeping items. We've applied for CLE and CPD credit for this session, and you can access the materials and attendance form from at the locations on the screen right now. Also, if you have any questions, please put them in the chat. We'll try to get to them, and if we don't get to them, then we'll follow up with you after, or please follow up with us after. Joining me today are Jamie Nafziger, the chair of our Cybersecurity, Privacy, and Social Media Practice Group in Minneapolis, Sarah Robertson from our Creative Industries Group in New York, and Kent Schmidt, a commercial litigator in our Southern California office. Thank you. I'll now pass it over to Jamie.
Thanks a lot, Dan. So one night recently, Kiff, a video streamer on the online platform Twitch, snuggled into his bed, continued to video live stream himself while he was sleeping, and woke up after a full night's sleep and had earned $5,600 from his stream. Given the events of this year, a lot of businesses have had to pivot to online, whether it was part of their plan or not. Online business in the US is up 107 billion year-to-date, year-over-year in 2020 in the US. And we can't all be as creative as Ms. Kiff in finding a way to earn money while we sleep, but online is definitely the place to be. Today, we intend to help you identify legal risks and business risks for your clients who are participating in this online boom from Canada. We'll try to keep it lively, but if you feel like you might start nodding off, make sure you at least turn on your stream before you do that. Here's our agenda for today. We have a lot to cover, so we're going to just jump right in, and we'll be switching off speakers as we go. So as Dan mentioned, I'm the chair of Dorsey's privacy practice, and so I'll be talking about the privacy issues we'll cover today. We're going to start off with the California Consumer Privacy Act. And probably a lot of you have heard about this. It's been in the news for the last couple of years. But you'll notice that we've tried to pick the legal risks in the US that might have the highest dollar amount damages kind of risks for Canadian companies. And you'll note that one theme that goes through quite a few of the issues we're going to talk about is where they have statutory damages and class actions. And this is the first such law and why people are so concerned about it. So I'm going to quickly go through who's covered by it, and then we can get into a little more of the meat of it, because I'm assuming that you're sitting there, if you haven't already figured out whether your company or your clients are covered, that's your first question is, does this even apply to us? So the first thing to determine to see if you're covered by this is whether your company collects personal information from California residents. One of the tricky parts about this is that it could be consumers who are coming to your website or your customers. It could be your employees if you have employees in California, or it could be business contacts that you have who might live or be in California. The second thing is you have to do business in California, which could be as simple as having a website that is used by people in California. And then there are 3 thresholds, and you just have to meet one of these. So either your annual gross revenues exceed 25 million US dollars, you buy, receive, or process personal information of 50,000 or more consumers, households, or devices per year, or you derive 50% or more of annual revenues from selling consumers' personal information. So most of the clients we work with are in one of the first 2 categories. The third category is more for data brokers or people that are really in the business of selling data. And the definition of sell under this law is very broad, so it probably covers most types of sharing that you might be doing. We believe these thresholds are based on global numbers, so 25 million globally, 50,000 consumers globally, but we're awaiting court interpretation on that. And then if you have a group of companies, to figure out who's included and how the numbers get calculated, if you have controlled or controlling companies and they have similar branding, they would be aggregated. So if we take the video streamer Miskiff, and there was Miskiff Shoes as one company and Miskiff Games as another one, they would probably be added together to come up with these numbers. Whereas if he had his game company with a completely different name, it would be considered separately. The enforcement risk, as I mentioned, is high for this law. There are actions can be brought by the Attorney General of California, and they have some pretty high dollar amounts that can be multiplied. Also, the big one that people are worried about is the statutory damages, as I mentioned. So it's $100 to $750 per incident, and then that's multiplied by how many people. So if you can imagine a database of 1 million people being breached, and then the class action that would come from that, it starts to get to very high numbers quickly. So what's happened this year? The law went into effect January 1st. The class action lawsuits began right away, and there have been more than 40 of them filed. So most times that a security breach is reported in California now, it is quickly followed with a class action lawsuit. They're mostly in the motion to dismiss stage, so we'll have to wait a little while to see how they all come out. Attorney General enforcement began on July 1st, and he sent out a number of enforcement letters right away. My understanding is they were based on consumer complaints and also, failure to have the required links on your website, or the very visible aspects of compliance were missing. I think he's said that he's going to focus on children and underrepresented communities, and then also respond to consumer complaints. So those are going to be probably some of his initial enforcement activities. They were all confidential, so we don't know what any of the letters were about yet, but we should start to find out soon, I think. The other big consequence we've seen so far is in mergers and acquisitions. Both on the side of the company who might be acquiring a company, doing much more due diligence as to CCPA compliance and the risk for security breaches. And then also for the company that might be doing the acquiring, being really careful about whether they might be acquiring a security breach that's already happened. Vendor agreements are really important with CCPA, so we've been working on a lot of vendor agreements, both representing vendors and companies using vendors, and they have certain required provisions, so it would be a good thing to review your vendor agreements to make sure they comply. Also, CCPA has financial incentive rules that relate to discounts. So we've had quite a few clients that were trying to do discounts, helping them figure out how to do that in compliance with CCPA. It comes up a lot with rewards programs. And then finally, a lot of our clients have started to get these consumer rights requests. And so we've been helping them figure out how to verify that the person is the person who's making the request, and then to comply with the request. What legal rights do people have under this law? It's pretty similar to the EU's GDPR, if you're familiar with that. It doesn't have all the same rights, but it does have the right to know what personal information is being collected about you, or how it's being used and how it's being shared. The right to delete that personal information. There are exceptions to that. The right to opt out of the sale of personal information. This relates to adding this button to your website, or this link that says, "Do not sell my personal info." And sale, as I said, is defined very broadly. So this hits a lot of even marketing cookies that might be happening or being used on your site. And then non-discrimination, that relates to that discount aspect I was talking about. I put the citation to the code here if you want to read it, but I think one of the big takeaways is just if a company has complied with GDPR or complied with Canadian privacy law, it doesn't mean they're compliant with CCPA. I don't have time to go into all the steps of compliance today, but there are a few I wanted to highlight. One, we're finding most of our clients actually need to go back to their data mapping that they've done in compliance with other privacy laws and update it and redo portions of it because of the California requirements. And then once they've got that data figured out, we can update their privacy policy, which we've been doing in terms of adding a California supplement. So you may need to, you or your clients may need to do that. I talked about the opt-out link. There's a lot of issues related to children. If you have employees in California, you need to have an employee privacy policy. And then finally, the developing your system to respond to these consumer rights requests is a fairly complicated system under the Attorney General's regulations. What's coming next? There's a November ballot initiative called California Privacy Rights Act, CPRA. It's likely to pass. You may have heard of Andrew Yang in the presidential contest here, and he has now become very active in promoting this law. It will, if it does pass, it will be effective January 2023. I've put some of the provisions here that would change. There's some that are good for business and some that are not. One of the things that would be good for business is that instead of 50,000 consumers, households, or devices, it would up the threshold to 100,000. It would also give a 2-year extension of some exemptions that have existed. There's also a new, this CCPA has been amended a number of times already, 2 in the last month. And one of them is this 1-year extension of these exemptions. So if you're familiar with these exemptions, they're likely to either be extended 1 year or 2 years. Right now, they're set to expire in January of next year. So it would become a really rush if none of this happens, but I think it will. So now I'm going to turn it over to Kent to talk about how to help your clients avoid those class actions.
Thank you very much, Jamie. As the discussion up to this point has already illustrated, California is a national focus for compliance, and that certainly is the case in spades with respect to privacy, as Jamie has just discussed. California, in one sense, is sort of like an alter ego of the federal government. It creates standards that, by virtue of its market power and the number of people who live in California, sort of become the default high watermark for standards in the rest of the country. So that's why there's a disproportionate attention to California and what's going on in California. And with class actions in general, that's also the case. Class actions are, particularly in the consumer space, are more common in California than almost any other state in the US. And of course, the US is sort of the leading jurisdiction in the world for class action. So there's a lot of attention being given over the last decade to the ways in which companies can effectively insulate themselves from class actions by having consumers agree to submit their disputes to binding arbitration, and in connection with that, to agree that the arbitration will be of a single claim and not of a collective or class claim. So, as often is the case in the law, it's best to understand this area of the law as a general rule with important exceptions and limitations. Since 2011, a US Supreme Court decision has given the green light to class action, arbitration, and waiver provisions. And I won't get into all of the sort of theoretical reasons behind that, but it has to do with federalisms and preemption of the Federal Arbitration Act. There are exceptions and limitations to that. The court recognized in that case that arbitration provisions must not violate other limitations on contracting, including contracting with consumers. So in this area of law, there's a significant difference between contracting with the consumer versus a business-to-business contract, what we'll call a commercial agreement. And in this area of law, the unconscionability standard applies to all sorts of provisions in a contract of adhesion, we call it, where it's a form contract that is presented typically on a take it or leave it basis, not negotiable. And in connection with those contracts, courts are very sensitive to both procedural unconscionability and substantive unconscionability, two very closely related concepts, one having to do with how the terms are presented, the fair notice that is given to the consumer as to these terms, and the other substantive unconscionability relating to how onerous the terms are to the consumer, how one-sided they are. So with that framework, there has been essentially a decade, almost a decade's worth of law seeking to apply this AT&T mobility versus conception standard and determine in what instances has a company crossed the line by providing a class action waiver and arbitration provision that doesn't meet the standard that is procedurally unconscionable or substantively unconscionable. And so these issues are frequently litigated in California as they are elsewhere. I think more in California because of our high incidence of class actions in California. And they're litigated even outside the consumer context. They're litigated in the employment context as well. And so it's important to understand this body of law and to try to obtain the big picture in crafting a provision that may be beneficial to the consumer. And so there may be resistance by the business folks to giving those concessions to the consumer, but will enhance the probability of that class action waiver being effective. So those are some of the issues that I think folks in the online space want to be thinking about when they consider class action waivers and their terms and conditions that are on their website or they're communicated in connection with the transaction for a sale or product. The next area that I'd like to cover quickly also relates to terms and conditions with consumers. As indicated earlier, when you have a contract with a consumer, and it's often the case that it is online in an e-commerce transaction, it's important to note that distinction that I mentioned a moment ago, the difference between consumer and commercial or business contracts. And with respect to consumers, there are limitations on warranties. There's a federal statute called Magnuson-Moss Warranty Protection Act. There's a similar state California statute that are similar but not exactly the same. And they limit the ability of a seller of a product. Here we're not talking about services. We're talking about only products and consumer products. But they limit the ability of a seller of a product to disclaim warranty and also to disclaim potential liability and remedies. And so it's very important to make sure that the disclaimer language in these contracts meets these standards, state and federal standards for consumer protection. I also just want to highlight the fact that increasingly products that are sold have both mixed uses. And a perfect example is the laptop computer that you're probably using right now can be sold to consumers and sold to businesses. And so that distinction needs to be thought about in a number of contexts, including warranties and also limitations of consequential damages, lost profits. You want to make sure if you're selling equipment or computers or laptops or even providing services to businesses that you have certain limitations on the liabilities, including not disclaiming lost profits, but then at the same time not run afoul of these warranty protections if you're selling that same product or service to a consumer. So it's a tricky balance to walk. There are other contractual limitations that can be very effective in limiting liability. And again, the difference between consumer and business is important to keep in mind. One of those is including limitations on when non-conforming goods can be rejected and the period of time in which a claim can be brought. On some certain circumstances, a company can essentially have the functional equivalent of a shorter statute of limitations. And in the class action context, if that can be validated, a shorter statute of limitations, you significantly limit the size and scope of the class. But again, there are limits to including those types of provisions in the agreement. The final point that I just want to raise before I turn it over to our next presenter is when you work very diligently to ensure that your contract terms, including class action waivers and the terms we just talked about, are effective and they address all of these issues, you need to make sure that it's going to actually mean something. You need to make sure that when you're in the process of presenting contract terms to the customer, to the end user, that the process of their indicating their agreement with those terms is effective. So here we have a situation in which a consumer brings a lawsuit and you point to all your terrific terms and conditions and everything that you've done so diligently, and the customer says, I've never seen these terms and conditions before. I'm not bound by these. You can have whatever you want in some passive display on your website, and those don't bind me because I didn't accept those. In fact, I didn't even see those. So in this area, courts have used the term browse wrap and click wrap to describe different ways in which terms and conditions can be presented or purportedly presented to consumers. And most of the law in this area has to do with consumers, but I think there's a lot of e-commerce being done with businesses as well. And the same principles apply in these business transactions as well. The point here is that a lot of folks understand the distinction between browse wrap and click wrap, but don't appreciate the more nuanced analysis for click wrap. So browse wrap, of course, is where the terms and conditions just passively exist on a website, and you are just assuming as the business that a user is going to go through your entire website and go to the terms and conditions and understand and read all those terms and conditions. Not a very safe assumption. Click wrap is where the customer has to do something, usually on the order page, indicating I agree to the terms and conditions. But a number of courts have said that just the fact that you have a customer that's checking a box and agreeing to the terms and conditions doesn't mean that they have been adequately presented with those terms and conditions. So courts get into some very technical issues, like are they hyperlinked next to the checkbox? Is a hyperlink a certain color and it's underlined so that they know that the terms and conditions are available? Is there, what's the color of the text? What's the language that is used? So I guess the takeaway from on these points is to re-examine, at the same time you're re-examining your terms and conditions, to also re-examine the precise way in which you are using the clip wrap function, usually at the order page, to confirm that if a dispute arises and you're facing litigation down the road, you will have a very effective argument that the customer must have understood and is presumed to have read and understood those terms and conditions. I like the phrase that some courts have used, forced confrontation. You want the customer to essentially be forced to confront those terms and conditions so that they don't have grounds to argue that they're a stranger to those terms and conditions down the road. And with that, I will turn it over to our partner, Sarah Robertson.
Thank you, Kent. We're going to cover some issues related to online marketing and in particular influencers. And with the onset of COVID the companies had to pivot to online marketing, so it's been increasing focus and growth, particularly over the last 6 months. So what is an influencer? An influencer can be anybody who has the power to affect a purchasing decision of others. And Jamie, you can switch to the next slide. This can range from brand ambassadors to bloggers to reality TV personalities, celebrities, YouTubers, gamers, even animals, affiliate marketers, and increasingly social media bots, which has been a focus of the FTC. So why is influencer marketing important to Canadian companies? The first is because of the low-cost access it gives to advertising in the US. Micro-influencers can be employed for low cost, and it has been viewed as a easy entree into marketing to tap into the US market. The second reason why it matters is the sheer growth of it. In 2019, it was estimated that the size of the influencer marketing category was at $9 billion. In 2022, it's estimated at $15 billion. And these were pre-COVID figures. So with the onset of COVID, that growth was very likely accelerated. So the regulatory framework for influencers in the US is important to Canadian companies for a number of reasons. One is that the FTC, which is responsible for the oversight of influencer marketing in the US, has started early in terms of issuing guidelines, enforcement action, with Canada following behind. And so the activity of the FTC can be instructive both for domestic compliance and also for those Canadian companies who are doing business in the US, what they would be subject to. The FTC recently, in February, again ahead of COVID, indicated that it would be, although its enforcement activity has been robust, that they would be escalating it even more. The FTC said they would be going after companies more aggressively. They would be communicating with the different platforms where influencers are appearing, and perhaps imposing requirements and restrictions on the platforms. They would be transitioning what are currently guidelines to the deceptive marketing statutory provision and codifying those so that they would be law as opposed to voluntary guidelines, and also potentially considering some requirements for influencer agreements, which we'll be touching on later. So this is a significant focus of the FTC pre-COVID, which, as I mentioned before, is sure to have accelerated. So in terms of the US regulatory framework, the primary guidance is from the FTC Act, Section 5, which prohibits deceptive marketing, but also the voluntary guidelines that have been updated over the years by the FTC. In terms of company participation, although influencers have been the subject of FTC enforcement action, brands have been ultimately responsible for the actions of the influencers, and it is the brands that are the most significant target for the FTC's activities, ranging from warning letters to fines to lawsuits, injunctions with potential for criminal liability if that would be pursued with in the case presumably of fraud. So influencers can't do what the company can't do directly. Companies are liable for what the influencers do, and as a result, due diligence before embarking on an influencer is particularly important. So an edict of and a focus of FTC enforcement action has been transparency in terms of influencer marketing. The nature of influencer marketing which is to use people or animals or bots to convey messaging and positive attributes of brands to give exposure to products and services. Because of the nature of the content involved, it's not always transparent when it's an ad and when it's not. And the FTC has been robustly and actively monitoring to make sure that there is transparency in that marketing and that the consumer deception doesn't occur. So the primary cornerstone is that there be a disclosure when there's a connection between an influencer and a brand. And the types of material connections that need to be disclosed are where it's a paid post or ad, where free product has been received, discounts or coupons have been offered, where the influencer is perhaps getting promotion from the brand in terms of reposting or tweeting or cross-posting, and anything else of value that would reasonably affect an endorser's opinion is material. And although this seems black and white, it has created a lot of violations and complications. One reason why there is so much difficulty in this area is because of the existence of what we call micro-influencers. Those are people who typically have 100,000 followers or less, who may be less seasoned or sophisticated, and those account for 45% of influencer activity. And so there's a lot of mistakes that can be made both on the brand and the influencer side. So some of the guidance that the FTC has given, which does mirror some guidelines that were put out by the Canadian Competition Bureau, are about use of hashtags such as ad, sponsored, free merchandise. There is certain platforms such as Twitter have led to some truncated hashtags such as SP or SPAWN, but those are frowned upon by the FTC. Influencers, to appear sort of keep a more casual and organic feel to their posts, tend to try to do things like say thank you or tag a brand, but those are not enough to comply with the FTC requirements. So there's no magic language so long as the disclosure is clearly and conspicuously made, but hashtags are generally found to be easy. So the requirement to disclose is as important as where disclosure occurs, particularly given the limitations of some of the platforms, such as Instagram. The requirements that the disclosure travel with the post, it not be buried after a string of hashtags, built-in tools, which in particular have been begun to be used on Instagram, have been found not to be enough, such that the features of the platform should not be relied on exclusively. And a most common issue that arises with the FTC is just lack of visibility of the disclosure. For example, where there's a long post on Instagram, it can require an additional click to get to the end, and the FTC wants to see that disclosure up front and readily visible, even if a click-through doesn't happen. Here are some best practices about videos and where those should appear, size, placement, visual and audio disclosures where appropriate. But the point is that different types of posts and content can create unique issues about how disclosures can appear. Affiliate links is one other area that we've had a lot of interest from Canadian companies as of late, and is one aspect of influencer marketing. This is where an influencer would have a link through its channels to a company product or service and would earn a commission if that link is used and a purchase is completed or other metrics or actions are taken. It can sometimes be unclear where it's a paid link or not. And again, disclosure that this is an affiliate relationship and that a commission can be earned are key to meeting FTC compliance. In terms of the US laws that can be invoked, where a commission is earned, it can also trigger other laws outside of the FTC, such as commission structure and requirements under various state laws. So keep in mind that a paid relationship such like this could raise other issues other than just marketing issues. Here, just to recap, it's to make sure the disclosure is upfront and close to the product recommendation. And so the transparency, again, is what the FTC wants to see. And despite the robust activity, at least for the 3 years, is something that that we see being done improperly a lot of the time. And in fact, I think the percentage is that 80% of the time, these types of disclosures are conveyed incorrectly. One primary risk mitigation tool from companies engaging in online marketing in the US is monitoring. And the FTC does realize that that companies, cannot be responsible for every single statement made by the members of their network. And so the level of compliance involved is not perfection, but what they want to see is some type of system in place by a company and some reasonable effort to see what advertising partners are doing and making attempts to comply, to ensure compliance. And so what we have been working with clients is some type of objective system for reviewing posts and ensuring compliance can go a long way in the FTC's eyes in terms of penalties or remedial action required. This can significantly mitigate the degree to which they slap a company on the wrist. And so something that is a important tool in your client's arsenal to reduce risk attached to the online marketing world. Again, some things I just mentioned, periodic checks, keep records, follow up with non-compliant influencers via email. We'll talk about influencer agreements later, but consider terminating influencers who are habitually non-compliant. And just a reminder that delegating responsibility for the promotional program, such as to an ad agency or a PR agency, won't absolve a company of liability. The FTC wants to see something objective and on paper that you can show that you were taking reasonable and objective steps to comply. Just briefly, before I pass it on, is user-generated content with, particularly during the COVID era where fresh content is hard to come by, reliance on user-generated content has increased. This is content put out by fans or people engaging with social media channels of companies. There can also be calls for content by companies, and there are some do's and don'ts in terms of how you use that user-generated content. The potential ways in which they could be used are a retweet if on Twitter, or a reposting, a sharing, engaging with that content, like commenting on it, responding, or as I mentioned, reposting on the company's own brand social channels and elsewhere. And this type of use of user-generated content can create a number of issues. One is if the content is making claims about a product or service, it can trigger an ad substantiation issue. This cream cured my back in 5 minutes. If that's reposted, it can be imputed to a company that it's a performance claim to its product. The other is copyright. You are reposting a photo that belongs to somebody else, and generally seeking permission, at a minimum giving credit, is important to stay on the right side of copyright concerns. Right of publicity can be triggered by people appearing in the photo or other content that you're using, and making clear that user-generated content does come from somebody else as opposed to originating from the company can also be an issue that arises. So there's caution to be exercised when reusing user-generated content to engage in an online promotion. Back to you, Jamie.
Thanks, Sarah. So I'm going to turn back to another privacy issue, which we've seen a lot of litigation regarding in the last couple of years, and it's biometrics. So fingerprints, hand, palm veins, iris scans, this kind of thing. Facial recognition, definitely. So then the biggest area of litigation has been the Illinois Biometric Information Privacy Act. By far. There are other states that have biometric privacy also, but Illinois is the place that's having high financial penalties. And that's because, again, they have class actions and liquidated damages. So it has some kind of technical requirements. So if you're going to use biometrics in Illinois, you have to give a written notice to people, you have to get their written consent, and you have to have a published data retention policy about what you're going to do with the biometric information that you've collected. And there have been a lot of cases in this under this law. The primary one that got the most news was a Facebook case that just got settled in January for $550 million. It was a class action where the class argued that Facebook didn't comply with these requirements in connection with tagging friends in photos. So that was a case to watch, but there are actually hundreds of other class actions pending in Illinois under this BIPA law. There are more filed every week. And lately they've started to try to, plaintiffs' class action attorneys have started to try to bring in vendors into these cases too. So whoever was the biometric software or hardware provider, they're trying to get some more deep pockets that can contribute to the settlements in these cases. There are other states in our country that have biometrics privacy laws. Washington and Texas also have very comprehensive biometrics laws, and then a lot of other states have added biometric information to their definition of personal information, so it brings it into lots of other privacy laws that already exist. So if you have clients that are using biometrics in Illinois, or you represent a vendor who sells biometric equipment or software, this would be a really good law to look at. A lot of the early cases came up with timekeeping systems. So if you have hourly employees, you know, in the old days, they used to have those punch cards to sign in and sign out. Well, a lot of people have transitioned over to thumbprints, and that is causing a lot of these cases. So it's good to be careful about. The other privacy issue I wanted to raise, just because it's not necessarily a new issue, but has had some recent very high stakes damages awards, is COPPA, the Children's Online Privacy Protection Act. And so last year we saw an FTC settlement with YouTube for $170 million. That's the largest ever COPPA settlement. And it was about YouTube videos and children under 13. So if you have a website or you have a client that has a website that has children that are users of it, you may want to check what kind of video platform are they using to host any videos that are showing, and does that platform actually comply with COPPA? Because the company that's hosting them could be held liable in addition to YouTube or another company like that. Also, children's privacy, as I mentioned earlier, has been a big focus in California. That new ballot initiative has even steeper penalties in connection with children, and the existing CCPA actually takes COPPA and adds more compliance on top of it. So it's definitely an area receiving increased attention in the US. I'm going to turn it back to Kent to talk about the Americans with Disabilities Act.
Thank you, Jamie, again. I'm going to cover two topics very briefly in the time that we have, and they're somewhat unrelated other than they both have to do with websites. The Americans with Disabilities Act, as most individuals know, is a law that was passed by Congress in 1990 to require companies to accommodate individuals with disability in both employment and in public accommodations. I spent a significant part of the first few years of my career measuring counter heights and sidewalk ramp levels and so forth in some ADA access cases. But here we want to talk about not the more traditional application of the ADA and these physical barriers, but of course how this applies to websites. The ADA has never been amended, and no regulatory action has been taken to specifically indicate that the law applies to websites. In fact, the law was enacted before websites really became a part of our normal everyday use, and certainly long before smartphones came to be used. But nonetheless, a number of courts have adopted the view that just as physical barriers and conditions have to be examined and have to be modified to accommodate for individuals with disabilities, so do websites and smartphones. There's been a fair amount of litigation activity and law that has been created by the courts in this area. And going back to the standard that applies in all ADA access cases, the standard of reasonableness or reasonable accommodation, the courts turn to the question of whether a website or a smartphone has features on it that reasonably accommodate individuals with visual or with hearing disabilities. The guiding standards in this area are the WCAG 2.0 standards by the World Wide Web Consortium. This is a classic example of where courts look to self-regulatory industries, SROs, or other organizations for guidance in determining whether a defendant's conduct satisfied a reasonable standard. So rather than this being a part of the Code of Federal Regulations, it's an independent non-governmental standard that needs to be consulted. At the same time, we have to remind defendants when we're defending these cases that this is not law, and that 100% compliance with every single specification in the standards is not required, and it does not create a cause of action if there's for example, a slight technical deviation. But I think you want to use a consultant that has knowledge, a web design consultant that has knowledge of these standards, and at least show that you have taken some initial steps to address some of the recurring issues that are often litigated. And I've listed those here. We have a lot of cases in dealing with the colors that are used on websites that are difficult for visually impaired individuals to distinguish. Pictures, it's easy to use tags for pictures so that someone can at least know what the picture is that's being displayed. And then when you get into more sophisticated websites and you're navigating, you're doing searches, you're placing orders, you have a shopping cart, things of that nature, you want to start looking at the navigation issues and whether the standards are followed. Still a fair amount of demand letters and consumer class actions being filed in this area. And so it's definitely something to be mindful of. The other area that I'll just quickly cover is recurring credit card charges. Anytime there is a website that has a credit card that is being charged on a continual basis, like a monthly subscription, these products and buyers clubs and boxes that show up on my doorstep, it seems like every other day I'm getting some sort of box of someone in my household has ordered these recurring gift or Stitch Fix or whatever that shows up on my doorstep. Those are very popular business model, and obviously the streaming services, whether it's Spotify or apps that have a monthly nominal charge. Anytime there's a charge, you want to ensure compliance with a California statute called the Automatic Purchase Renewal Statute. And it addresses things that are listed here. We probably don't have time to go into each one of these, but some of the issues that we talked about earlier that relate to font sizes and how clear something is in front of the consumer are also dealt with in the statute and in cases that have interpreted the statute. What you are aiming for is that the user is not able to argue later on that they didn't understand that their credit card would be charged on a recurring basis, and that they understood this wasn't a one-time charge. This would be something that would happen each month or whatever the terms are. And that that notice is in contrasting color, a larger font size, is not the typical fine print that is going to create an argument that there was unfair surprise by the customer. So the statute is pretty technical, and compliance is a challenge, and they're very well established, well-known household names of companies that have been sued under the statute, and class action have paid out very significant settlements. So it's definitely worth taking a look at the statute. Again, it relates to the browse wrap issue and text wrap issue, or the browse wrap and click wrap issue that we talked about earlier. And finally, when a user is intending to withdraw and terminate the subscription or other recurring charge, you need to make sure that you have the infrastructure in place and the personnel in place to process those orders, because claims can be brought, even if everything else is done correctly, simply by continuing to charge after a termination has been done. And I think it's back to Sarah Robertson, right?
Yeah, thank you, Kent. Just in the interest of time, just very briefly, we're going to go back to influencer contracts. And as I mentioned, the FTC announced in February that this would be an area of focus for it coming up. And influencer contracts are increasingly being used by our clients and are really sort of a modern form of talent agreement, that they can be beneficial for reducing liability and ensuring compliance with the FTC requirements related to this area. And so just a few comments on what they look like. They can be particularly in the case of a micro-influencer or a client or company with a smaller budget. If it's going to be a one-off campaign, it can be a single agreement that has a very short term. We've seen master agreements with statements of work, which allow a company and an influencer to work on a series of campaigns while employing the same document. And what we are seeing is a shift towards agency use, which helps companies and clients manage and recruit these micro-influencers, and a company standard form that would apply to those influencers recruited and interested would be uploaded to those agency platforms. So some things to think about, how well do you know the influencer, your due diligence, do they fit with your brand image, and particularly brand safety? Are they consistent? Looking for, again, consistent behavior, and behavior that's also consistent with your brand mores and values. What type of deal is it? Will you own the influencer's content? Will your company get the right to use it only and repost? These are things that are negotiated terms. And again, as mentioned, the compliance with laws and spelling out the applicable regulatory framework. For a Canadian client, it could be the Canadian structure along with the U.S. structure is a very important part of these agreements. Again, so that it is so that in terms of the monitoring obligation in particular that we discussed, spelling out clearly in a contract what you expect the influencer to do, providing some pre-approval, particularly at the beginning of the relationship, and also some training can go a long way in terms of reducing the impact should a slip-up occur and the FTC appear with some corrective enforcement activity. Letting influencers know you're monitoring, an obligation to take down a post that's non-compliant so that a deviation can be scrubbed and taken down. Also, a termination right for non-compliance is important. For present activity as well as any past activity that may come to light during the course of a relationship. Back to you, Jamie.
Sarah. So in our remaining moments, I'm going to cover two laws that have been around for a while, so you've probably heard of them, but they continue to involve high stakes dollar amount cases. CAN-SPAM, which relates to email marketing. The points I want to make about this is that it applies to all commercial emails, not just the bulk emails. Some clients just think of CAN-SPAM when they think of these big sets of emails that get pushed out, but it has a lot of content requirements, both in terms of the headers, the subject lines, what needs to be in the email itself, and people get tripped up on these technical requirements and often will have cases that involve a lot of money because the penalties can be up to $41,000 per non-compliant email. And you can imagine if you are sending out a big campaign, how that could quickly mount a large amount. So the other thing is, like Sarah was talking about for having an outside agency, a lot of people are having outside agencies run their email marketing, but the company that's hiring them still remains liable for what the vendor might be doing. So it's important to monitor what the vendors are doing. I put some examples if you need to talk with clients about why they should take this seriously of some recent cases and the dollar amounts of the damages. You'll see some of them that are in the 1 to 2 million. It was just a failure to provide the opt-out and postal address that are some of the technical requirements of the law. The other one I wanted to talk about was the TCPA, Telephone Consumer Protection Act. This one deals with telemarketing calls and also text messages. And it has been the subject of a huge number of very expensive class actions because, again, it has statutory damages that you multiply by the number of text messages that were sent, and it turns into huge damages. And there are people out there who are actually like buying up 70 phones and then waiting for text messages that they shouldn't be getting that are not TCPA compliant, and then filing these class action lawsuits. There's a lot of plaintiffs' activity in this area. There's currently a circuit split as to what it constitutes an automatic telephone dialing system. Some courts have had such broad rulings that it basically would make any smartphone an ATDS, and others don't hold it to be that broad. The US Supreme Court recently granted cert to actually review this issue in a Facebook case that I put on here. It's set for argument on December 8th, 2020, so this is an issue that will be good to watch in the coming year. Thanks very much. We've got some final tips that we put for your takeaway that you can review. Hopefully you enjoyed the talk and stayed awake, and I'm going to turn it back to Dan.
Thanks again, everybody, for participating. There is one question in the chat that we unfortunately didn't have time to get to. We will reach out to you and give you that answer. If anybody else has any questions, please reach out to us and we will be more than happy to chat. Thanks again, and we'll talk to you soon.
Thank you.
Take care. Thank you.